For today's story, we talk about an attorney who said some perhaps unfortunate things online, got a whole bunch of one-star reviews on Yelp, and is now suing for defamation. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn your subscription. But first, a huge thank you to the sponsor of this video, Aura. Aura is a new type of security service that helps to protect your online accounts, internet connection, and devices with one simple subscription. With an easy online dashboard and alerts sent straight to your phone, Aura keeps you in control and guides you through solving any issues with Aura's excellent customer service. All plans, of course, come with $1 million in identity theft protection insurance and an experienced US-based customer support team that has got your back every step of the way. So if you want to secure your online presence from hackers, scammers, and nosy advertising companies, please go visit aura.com/uncivillaw. And when you use my link below, you'll get up to 40% off all plans. Plus, there's a money-back guarantee. So if you don't like aura.com, you can cancel and get your money back. aura.com/uncivillaw to help you protect your identity and your credit from increasing threats in our increasing digital age. For today's story, we are dealing with David Friedan versus Victoria Chairman. In this story, David is an attorney. He said some things on the social media. People objected to the things he said on the social media. So then basically a whole bunch of people review bombed him on Yelp and other things and gave him a whole bunch of one-star reviews. He is now suing everyone in sight for defamation. Well, can he do that? Well, the Court of Appeals for the Seventh Circuit has some thoughts on the issue, so let's get started with this. On a late September day in 2017, David Friedan, a Chicago lawyer, posted a question on Facebook. Quote, "Did Trump put Ukraine on the travel ban list? We cannot find a cleaning lady." Okay. After receiving online criticism for this odd and offensive comment, Friedan doubled down in the comment section, saying the following, quote, "My business with Ukrainians will be done when they stop declaring bankruptcy. If this offends your national pride, I suggest you looking for underlying causes as to why 9 out of 10 cleaning ladies we've had were Ukrainian, and 9 out of 10 of my law school professors were not. Until then, if you don't have a recommendation for a cleaning lady, feel free to take your comments somewhere else." Okay. So as things happened on social media, things escalated from there. There were some more comments and some more things, and people got angry. Ultimately going to people leaving comments on his firm's Facebook, Yelp, and Google pages. They left reviews that expressed their negative views of Friedan. These reviews range from simple one-star ratings to detailed comments about Friedan's, quote, hatred and disrespect towards the Ukrainian nation. Defendant Victoria Camara's one-star rating contained the longest commentary. This is the person who's being sued. A lot of people are being sued, but she's the first named defendant among many. I'm not sure how she became the first named defendant, but she is. In any case, Victoria over here called Friedan an embarrassment and disgrace to the U.S. judicial system, referred to his comments as unethical and derogatory, and labeled him a hypocrite, chauvinist, and racist, who has no right to practice law. Other defendants were more concise. Defendant Titania Kravak said Friedan is not professional and discriminates against other internationalities, and she told people not to waste your money, while defendant Anastasia Shomalaka wrote that Friedan is biased and unprofessional attorney. These statements also accompanied one-star ratings. And various other one-star ratings from John Doe defendants complained of terrible experience, awful customer service, disrespect, and unprofessionalism. Perhaps somewhat notably, none of the defendants have previously used Friedan services. So we see a potential conflict or a potential issue, right? So the question might become, okay, is this defamation? Is this the kind of thing the law is meant to protect? Well, that's why the Seventh Circuit's here, so let's read on. On the liable theory, the courts deem the comments defamatory per se because they fall under a per se category of prejudice to a person in his profession. But since the comments were all opinions, they all had the benefit of affirmative defenses and were not actionable under the First Amendment. Plaintiff's civil conspiracy claims failed because they were not supported by any underlying tort. At a status hearing, the district court denied plaintiff's request to amend the complaint. He said, "I think that this case should end now, so the motion to amend is denied." The judge later clarified in a written docket entry that this decision on the motion to amend was the final decision that started the clock for filing a timely appeal. So the plaintiffs now file that appeal to the district court's dismissal of their claims, and they challenge the denial of the motion to amend. So the district court said, "Hey, not so much. You can't sue." He says, "Can I amend?" The district court says, "No, you cannot amend, so go away." So he's appealing both those things. He's appealing the decision not to allow him to amend, and he's also appealing, of course, the underlying merits decision of that this is not defamation. To survive a motion to dismiss under Rule 12b-6, a complaint must contain enough factual content to state a claim for relief that is plausible on its face. A statement may be defamatory per se and still not be actionable if an affirmative defense applies. Illinois has 4 affirmative defenses, one of which is relevant here, the expression of opinion. The defendants assert that all their comments were statements of opinion that are not actionable. We agree. To aid in this legal determination, the court asks the following: whether the statement has a precise and readily understood meaning, whether the state is factually verifiable, and whether the literary or social context signals the statement has factual content. The test is restrictive. A defamatory statement is constitutionally protected only if it cannot be reasonably interpreted as stating actual fact. But if it's plain the speaker is expressing a subjective view, an interpretation, a theory or conjecture, or surmise, rather than claiming to be possession of objective facts, the test is not actionable. Okay, so one of the things here in the middle that you might want to note, just as way of legal education, is when you come up with a statement, how are you supposed to understand it? Do you understand it? Do you look for whether or not it's capable of being understood as factual, or do you interpret it as whether it's capable of being understood as opinion? Right? So those are two different things you could do as a court. Is this capable of being understood as a fact? If so, then it's factual and go to a jury, because whether, it could be understood that way. Or is it capable of being understood in opinion? Right? Is this capable of being understood the other way so that it would be dismissed? So different courts look at this slightly differently, and this is one of the areas that differs in defamation law among the states, is which way they go. So is there also this innocent construction or not? Is this difference of opinion? So is this capable of some innocent construction, or is it capable of a non-innocent construction? You can go either way on those issues too. So how you perceive this dictates the answer. The plaintiffs and the law firm point to terrible experience, awful customer service, and don't waste your money as examples of implied statements of fact contained in the review. So as we all know, or we've discussed at least before, something that looks like an opinion expresses secret facts or private facts, then the opinion might be understood to convey the facts, in which case it's actionable. So if it's based on some private facts that you have and you express the opinion and it's understood to rely on those private facts, then it's understood to convey the facts as well, even though it looks like an opinion. So that's what they're talking about. So here, they say that terrible experience, awful customer service, and don't waste your money imply facts. Okay, the court continues, we do not read them that way. First, the statements do not have precise and readily understood specific meanings. Granted, there are easily understood phrases in the English language, but there are numerous reasons why someone might have had a terrible experience, or suggest a product or service would be a waste of money. Without additional detail, the use of these phrases cannot be understood to be precise. I could very easily see a different court analyzing this differently, incidentally. So while this is a valid construction in the Seventh Circuit, it would not be surprising to me if there was case law in other circuits that differ from this. I don't think that merely because these are open, unfiltered, and because perhaps we should be skeptical of these comments mean that people necessarily are skeptical. I think there are people who believe everything they read on the internet because some people are dumb. I think even quote-unquote reasonable people can be dumb. And I don't think you have to really be dumb to understand that these comments purport to present some facts, namely that they were a customer. And even if you're skeptical of those things, it still doesn't matter for the purposes of defamation, because it relies on whether or not false statements are communicated to a third party. The point is not whether the individual commentator had direct consumer relationship with the business that they reviewed. Rather, we ask if a reader could understand whether the reviewer was expressing opinions or facts, which I think is a perfectly reasonable thing, but at least I think a reasonable reviewer could understand them to be communicating facts. The Seventh Circuit disagrees with me. The comments in this case fall clearly on the side of opinion. I'm not 100% about that one. All this line, plaintiffs contend that hypocrite, chauvinist, and racist were not statements of opinion. These are statements of opinion. I agree. We have explained why we view these statements as opinion. More generally, Illinois defamation treats comments of this nature as actionable when based on identifiable conduct, but non-actionable when stated in general terms. This is more in line with the typical case law. Right. If you just say someone is a hypocrite, chauvinist, racist in just by itself, that is non-actionable opinion. So here, I agree with the Ninth Circuit as to that much at least. Additional comments made by Camara in her longer review are closer calls, but ultimately non-actionable opinion statements when analyzed in the correct context. Now, I will give them that this is correct. You have to analyze them in context. This is very true. You have to understand defamation statements or not based on the entire context of all the stuff, right? You can't just pick a sentence out of isolation and say, well, that sentence is defamatory. As explained above, we consider social context that these reviews appear to determine whether a reader would interpret them as expressing opinions or fact. But the context analysis is twofold. Courts must also analyze the entirety of a review a comment appeared in to determine whether a reviewer expressed statement of opinion or fact. Now, I don't know about the law on this one in terms of whether or not you should analyze. Now, I understand you should review a person's statements, viewed in everything they said. You can't pick out one sentence in isolation. That's a no-go. You have to look at everything they said. But do you go beyond that? Do you go beyond the statement to other statements? And that seems like a questionable proposition to me, because I don't know that a reasonable person reading it would necessarily view one statement in the context of another. They all purport to be individual reviews. Here is the full review from Chimera. Okay, so let's understand at least this comment on its own terms and do some analysis. I'll do some analysis about whether or not it's defamatory based on its own terms, in the entirety of its own terms. So here's what they said. David Friedan is an embarrassment and disgrace to the U.S. judicial system and has no right to practice law. His unethical and derogatory comments, which target one particular nation, Ukrainians, show who he really is. He portrays himself as someone who cares about the interests of his clients, the majority of which happen to be Ukrainian, but in reality, he's a complete hypocrite, chauvinist, and racist. He does not hide his hatred and is disrespectful towards the Ukrainian nation on his personal Facebook page. Such an attorney is an embarrassment to any law firm. Okay, so as to this comment, standing by itself, I have no problem concluding this statement is a matter of opinion. Plaintiffs here never showed the district court how they thought they could amend their complaint to cure deficiencies. Even in this court, plaintiffs also did not indicate in their opening brief what they would have alleged in an amended complaint. Not until the reply brief did they provide any concrete information. Yeah, that's too late. So you're going to lose on procedural reasons here. Right? If you had brought it up earlier, maybe, but you only brought it up in your reply brief. No, you can't do that. Thus, that brings us to the end of the case of David Friedan versus Victoria Camara, a very interesting defamation case, which I am not confident would necessarily come out the same way in other circuits. As to the leave to amend, the district court is supposed to give one for free, and it might have been an abuse of discretion, but fortunately, I don't really have to worry about that because David over here screwed it up. David screwed it up by not saying what he would have put in an amended complaint in the brief until the reply brief, and that's just too late. So he waived that error. So assuming the district court made a mistake, he has waived the mistake, so I no longer care for procedural reasons. However, I'm not 100% convinced on his unamended complaint he should lose. There seems to be areas of the law where I agree with the Ninth Circuit. Merely one-star reviews by themselves and this longer review that was led by Camara seems to be fine as an opinion, but there are other things that seem to imply statements of fact. Bad customer service, at least in my mind, implies that there was customer service. Not worth the money implies that, you received some sort of quote, or you otherwise had a context to be able to determine how much money you're spending. But that's the law in the Seventh Circuit, and at least as to that much, that brings us to the end of the conclusion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.